Imagine 50 protesters marching down a crowded high street. Approaching a heavily guarded corporate headquarters, they suddenly drop to the pavement and lock arms. In England and Wales, the starting point for analyzing this scenario is straightforward. Processions and meetings are prima facie lawful, unless the participants commit specific crimes or torts. Let's look at the exact facts of our problem question. 50 unannounced marchers move down a high street. They stop outside a corporate building and begin a noisy, static demonstration. In response to the noise and the sudden halt, the chief constable arrives and immediately issues a blanket ban, ordering the gathering to disperse. We have to determine if this ban is lawful. The legality of the police response depends on the rigid structural dichotomy established by the Public Order Act 1986. The statute completely separates the law governing moving groups, categorized as public processions, from static groups, categorized as public assemblies. General appeals to human rights or free speech will not secure high marks in an exam. Resolving this scenario requires routing the facts through the exact statutory definitions and thresholds of the 1986 Act. We begin with the initial march. The definition of a public procession comes from the case of Flockhart v. Robinson, where Lord Goddard defined it simply as a body of persons moving along a route. Under Section 11 of the Act, organizers of a public procession must provide the police with 6 clear days' written advance notice of their exact date, time, and route. This flowchart illustrates the decision matrix for the advance notice requirement. Notice the central nodes determining if notice is reasonably practicable. Looking at the lower branches, the statute explicitly exempts funeral processions and commonly held processions entirely. This customary exemption was tested in K v. Commissioner of Police of the Metropolis. A large unorganized mass of cyclists held a ride through central London on the last Friday of every month. Because the critical mass rides had no central organizers and took a highly variable, unpredictable route each time, the legal issue was whether they were legally compelled to provide advance notice under Section 11. The House of Lords ruled that they were exempt. Despite the lack of a predetermined route, the long-standing monthly pattern classified the rides as customary, placing them outside the notice requirement. When police want to intervene in a procession, they have 2 distinct statutory tools: imposing conditions under Section 12 or prohibiting the procession entirely under Section 13. A senior police officer can impose Section 12 conditions only if they reasonably believe the march will result in serious public disorder, serious damage to property, serious disruption to the community, or widespread intimidation. The exact definition of serious disruption became heavily litigated after the government introduced the 2023 regulations, which controversially attempted to lower the threshold to encompass any disruption that is more than minor. Section 13 bans are far more restricted. A chief officer of police cannot act alone. They must apply to the local authority, and the local authority must secure the consent of the Home Secretary. This leads to a major exam pitfall. Even with that high-level consent, Section 13 only permits banning an entire class of processions, such as all political marches in a district for up to 3 months. The police can never use Section 13 to ban a single specific individual procession. Therefore, any attempt by police to ban a specific moving march is ultra-virus and unlawful. Once a group stops moving, the legal framework shifts. Section 16 defines a public assembly as an assembly of 2 or more persons in a public place, wholly or partly open to the air. Unlike processions, 0 advance notice is required. The spatial limits of assembly law were tested in R. Baroness Jones v. Commissioner of Police of the Metropolis, arising from the Extinction Rebellion autumn protests. The police issued an order mandating that any assembly linked to the movement across London must cease. The court had to determine if Section 14 conditions could be applied globally to an entire citywide umbrella movement comprising multiple separate and distinct localized protests. The High Court ruled that a public assembly must be tied to a specific location that can be fairly described as a scene. Separate gatherings, distributed across time and miles, do not constitute a single assembly, rendering the broad citywide condition entirely unlawful. Beyond imposing conditions, the Criminal Justice and Public Order Act 1994 introduced Section 14A, creating police powers over trespassory assemblies. This map illustrates the strict thresholds required for a Section 14A ban. It targets land with limited or no public access, requires a minimum of 20 people, lasts a maximum of 4 days, and cannot exceed a 5-mile radius. These geographic limits were examined in DPP v. Jones, where a group of 21 protesters held a peaceful, non-obstructive demonstration on a highway near the Stonehenge Monument, inside a restricted 4-mile radius. The protesters were arrested on the premise that assembling on a highway automatically exceeded the public's right of passage, making the gathering trespassery. The House of Lords rejected this. They ruled that the public highway can be used for reasonable activities beyond merely passing through. A peaceful assembly is a lawful incidental use of the highway, provided it does not unreasonably obstruct passage. Examiners actively test this distinction. Section 14 conditions can be imposed on just 2 people anywhere in public, while Section 14A bans demand strict 20-person thresholds, specific geographic limits, and restricted access land. Alongside these statutes, police retain common law powers to prevent a breach of the peace, defined in R.V. Howell as actual or likely harm to a person, or in their presence to their property. Historically, police utilize this doctrine to preemptively stop protesters miles away from their destination if a breach of the peace was reasonably apprehended, a controversial tactic that was used extensively during the 1980s miners' strikes. The Human Rights Act 1998 altered this landscape by forcing courts to rigorously protect European Convention rights, specifically Article 10, Freedom of Expression, and Article 11, Freedom of Assembly. The clash between broad common law discretion and human rights was resolved in the Laporte case, where police intercepted coaches carrying 120 anti-war protesters. Fearing violence, police stopped the coaches and escorted them 90 miles back to London. The issue was whether turning a coach around at that distance was a lawful preventative measure. The House of Lords laid down a strict rule. Any preventative action short of arrest requires that the anticipated breach of peace is strictly imminent. By acting 90 miles away, the police intervention was premature. It was also indiscriminate, targeting the peaceful majority on the coaches instead of identifying the minority who actually intended violence. The court concluded the police action was an unlawful and disproportionate restriction of convention rights. Any police intervention, whether statutory or common law, will fail judicial scrutiny if it cannot prove a proportionate response to a strictly imminent threat. We can now resolve our initial problem question using a 3-step analytical checklist. Identify the format, apply the correct POA section, and test for proportionality. Step 1. As the 50 individuals marched down the high street, they constituted a procession. Because they gave no advance notice, the organizers committed a Section 11 offense, but the march itself remained lawful. Step 2. The moment the group stopped outside the corporate building, the legal format changed. It instantly became a Section 14 public assembly, which requires 0 advance notice. Step 3. Assess the chief constable's immediate ban. Section 14 only permits the imposition of conditions on an assembly. A Section 14A ban requires local authority consent and restricted access land. Acting unilaterally, the chief constable's ban is illegal. Applying the Laporte standard reinforces this. Without explicit evidence of imminent violence or harm to property, a blanket ban fails the Article 11 proportionality test. The chief constable had the authority to impose a proportionate condition under Section 14, such as limiting the duration or the noise level, but issuing a blanket ban was ultra vires. Mastering public order law requires strict statutory precision. Police actions that blur the line between conditions and bans or fail to prove an imminent threat will always be deemed unlawful.